Morning, everyone. I'm just waiting for about another 20 or people or so to join. We've still got a few minutes. I can't see you, I can't hear you, no one else can see or hear you, but hopefully you can see and hear me. There's a chat facility at the bottom of the screen. I've just put a few notes in there, just a few housekeeping bits, but once a few more people have joined, I'll go through them before I start. Hi, Samantha.
Hi.
Is there a problem?
Oh, can you hear me?
Yeah, I can hear you, but I've got everyone muted, so...
No, that's fine. Sorry, yes. That's fine. You mute me again.
Okay, that's fine. I just want to check, but you can see me, you can hear me?
Yes.
Perfect. Okay, great. You've still got quite a few more people to join, so I'll just give it a couple more minutes. I don't know whether it's a good idea to finish my coffee or not, probably not. Right, we've got most people now and it's 10 o'clock, so I'm going to crack on because I've got quite a lot of content to get through. Just a few housekeeping bits before I start. I have put in the chat, which you should be able to access at the bottom of your screen, a few housekeeping points. But basically, because there is so much content to cover, I've got everyone muted and your videos are off, so you can't see or hear anyone else, but hopefully you can see and hear me. It's the important thing, or at least hear me. If you've got questions as I'm talking, please could you use the Q&A facility at the bottom of the screen. I'll either answer the question as I go through, just because it's part of the content, or I might see the question and be able to fit it into what I'm saying, or at the very end, I'll just go through the questions and answer as many as I can. If I can't get to any questions and there's still questions, then I'll copy them all and I'll come back to you separately. At the end of this, you'll get a copy of the recording, you'll get a detailed handout that covers everything that I'm going to discuss. So don't worry too much about trying to copy down everything that's on the slides, because you'll get a copy of all of that. So just yeah, just hopefully you find the content interesting and relevant, but any questions, as I say, just pop them on the Q&A. If there are any technical issues, perhaps just pop that on the chat or call the main number, because I might not necessarily see it as I'm going through, but hopefully I've tested this a few times, so hopefully everything will work okay. Right, I'm going to just start then. We've got most people now, so I'm going to make a start because we've got so much to get through. So, why consider sponsorship? First thing, that obviously the impact of Brexit means that any EU national who doesn't qualify under the settled status scheme, which as you probably know ends, the cut-off date is tonight for applications, won't be able to work lawfully in the UK without sponsorship. Now that's assuming, of course, that they don't qualify by some other route, and there are plenty of other routes like UK ancestry, through marriage, and lots of other alternative routes. But in this session, I'm basically assuming that we're always talking about an individual who hasn't qualified by another route, and so we're looking at sponsorship. But of course, it's not just EU nationals. We kind of targeted this as EU nationals because it ties in nicely with the date, and that's obviously created a lot more need and interest around sponsorship. But the same rules apply to any non-British citizen who wants to work in the UK. EU nationals aren't getting any special treatment under the immigration rules. I think the only benefit they get is around the mechanics of how they give their biometric data, but otherwise there's literally no special treatment. So it will have a massive impact on our labour market, on employers, on the economy. The flip side of that is that the government has massively overhauled the immigration scheme, and it is actually a lot easier to sponsor someone than it has been in the past, which might not seem that way if you've ever had to go through the process, because they don't particularly make it easy. Some of you are from organisations which already have a sponsor licence. I'm just going to, hopefully this will work, I'm just going to pop up a poll to see, this is all anonymous, but just to see whether your organisation has a sponsor licence. So a poll should have popped up. If you wouldn't mind just letting me know whether you've got a sponsor licence already or not, and then I can get an idea of who I'm talking to. Okay. All right, so we've got a mix. I think most people here, your organisation does hold a sponsor licence, some don't, a few not sure. Okay, that's really helpful. Thank you for that. So what I'm first going to talk about is what's involved in obtaining a sponsor licence. Now, although there's some of you here that already have a sponsor licence, this information is still relevant, because all of the things that you have to do to be able to apply for a sponsor licence are still relevant when you have a licence. They're a helpful reminder of the expectations the Home Office has of you as sponsor licence holders. So it's still relevant for everyone. There's a lot of information we could cover here. I mean, I could spend a whole day talking about sponsorship. No one would want to listen to it. What I'm going to do is approach this from a high level point of view, so we can cover all of the topics that I said I would. Like I said, at the end of the hour, I'll look to answer as many questions as I can. So please do send any questions you've got as we go through. Okay, so first, I'm going to go through a little overview of sponsorship. So there's broadly two types of licence you can apply for: a worker licence, which was formerly known as Tier 2, and the temporary worker route, which was the former Tier 5 route, temporary workers. So within those two types, there are then quite a few different immigration routes. Now, as a sponsor, you can apply to be licensed in as many routes as you feel is appropriate for your business or organisation. For example, organisations who have sister group companies abroad tend to apply for an intra-company licence, as well as what is now the skilled worker licence. Now, just note that if you're an organisation that already has a sponsor licence, there's nothing you need to do. Whatever your licence used to fall under will have automatically been updated to the new worker or temporary worker, ICT, whatever it might be. So the two main types of licence is what we'll go through. I don't intend on going through each route in detail. For most clients that I speak to, and probably most people here, the most relevant are likely to be skilled worker and intra-company transfer. So the skilled worker route allows employers to recruit people to work in the UK in a specific job. A skilled worker must have a job offer, and it has to be in an eligible skilled occupation. It has to meet the relevant salary and going rate requirements. So we'll go through that in a little bit more detail in a minute. The intra-company routes, now there are two ICT routes. Both of them need the worker to be sponsored in an eligible skilled occupation and meet the salary and going rate requirements. So the two main ICT routes are the general ICT, so that's for an established worker who's being transferred by an overseas business that they work for to do a skilled role with a linked business in the UK. So in that situation, they usually need to have 12 months of employment in the overseas entity. There are some exceptions for high earners. It's very high earners. We're looking at 70k plus. The other ICT route is for graduate trainees. Now that's for workers who are being transferred to undertake a role in the UK as part of a structured graduate training programme. Now, their employment requirements are much shorter, so they only need to have been employed for 3 months in the overseas business. The temporary worker routes that I'll point out, I mean, I've listed all of the routes under each category on the slide, but the ones that I just want to bring your attention to very briefly are charity worker. So that's for someone who wants to come to the UK to do voluntary work with a charitable organisation for no more than 12 months. Seasonal worker, now this will be relevant for a lot of our clients in the horticultural industry because it is specifically for workers in that industry who need to come to the work to do seasonal work. Sponsors have to be an approved scheme operator, and those workers can only come for up to 6 months in any 12-month period. And then the last one really to point out is the government authorised exchange worker, GAE. So that's for someone who wants to come to the UK on an approved scheme for a period of no more than 12 or 24 months, depending on the scheme. So this is going to be for typically younger workers coming to do an placement or an internship. I'm getting quite a few queries now around businesses who want to bring people from group companies abroad to do training, work placements, internships. They do have to be sponsored. It's not easy to obtain a GAE licence. It's probably not a case where you as an organisation would apply for one. In most cases, you're going to be looking at working with an organisation that's already approved. In the handout that you'll be sent, there's links. I've included links to the government page that shows you who the current approved organisations are, sponsors for GAE, and the guidance for that, so you can do a little bit more reading around that if you like. It's not something that I've spent a lot of time working on, so but it's a good one to know about. The other really important one to point out, which some of you are probably aware of, is the Youth Mobility Scheme, or YMS, T5. So that's quite widely used. Some of you will have employees on a YMS visa. YMS is open to 18 to 30-year-olds who are from one of 9 countries, which includes Australia, Canada, New Zealand, Japan. So they can work for any employer in the UK. They don't need to be sponsored, and they can work for up to 2 years on that type of visa. They have to have prove that they've got about £2,500 in savings. So it's quite it's a really flexible visa that a young person can use. So if you're looking to sponsor someone and you're not a sponsor already, or it's not a highly skilled role, it's always worth thinking, hang on, how old are they and where are they from? Because we might be able to use YMS. One thing to note on this is that recently Australia and the UK agreed to extend their reciprocal arrangements on this. So there's no definite date as to when it's going to come into effect, but it should be sometime over the next 5 years. But it will be extended so that it will be open to up to 35-year-olds, and the visa can last for 3 years. Don't know yet whether that will extend to other countries as well, but certainly for Australia and the UK. So moving on to the process of applying for a licence. So as I said, these factors are also important for employers who already hold a licence. The Home Office can conduct an audit on any employer, not just sponsor licence holders, but any employer at any time. If you're a sponsor licence holder, you're subject to greater scrutiny. You've got a higher obligation to help prevent illegal working. So the first steps before you even launch into the sponsor application process is to make sure, of course, that you're not employing any illegal workers, that your right to work checks are adequate. So carry out checks for all of your employees, not just those you think aren't British, that you've got adequate HR systems in place to manage for the licence. And this is a really important one and something which is quite easy to slip through the cracks. So for example, it's important to have systems in place to trigger when you might need to make a report about a sponsored worker. So you might have someone sponsored, their manager might decide to change their role. That needs to be flagged to whoever has responsibility for that sponsored worker in the HR team, because it might be that it affects their immigration status. But once you're happy that your HR systems and records are compliant, you can go ahead and start the process of applying. The first step is to always look up and refer to the latest Home Office guidance. They do change it really quite regularly. Again, the pack that we'll provide you after the session has got links to all of those guidance notes that you need. So stage one is information and document gathering. And I really can't emphasize enough how time consuming and challenging this part of the process is. Even with the best systems in place, it can take several weeks just to gather everything that you need. In the majority of cases, I've found it takes employers longer than this. Sometimes it's taken several months. It's important to factor that into your timeline where you don't already have a licence. It's really important to determine who will be involved in managing the licence. And this is something that's important for existing licence holders, because when you first apply for the licence, you specify who's going to be carrying out what sort of role. So you have an authorising officer, you have a key contact and a level 1 user as a minimum. You might have additional level 1 users, you might have level 2 users, but those 3 roles as a minimum. You need to make sure once you've got your licence as well that you have systems in place for what happens if our level 1 user or our authorising officer is leaving the business. If they leave the business and you don't have an authorising officer, you're at risk of losing your licence, worst case scenario, because the immigration will say you must always have someone fulfilling those roles. Their key roles, those people are responsible for, especially the authorising officer is responsible for all sponsored workers. You'll need to gather information about those individuals, so their full name, business contact details, date of birth, that sort of thing. You need to gather information about the business, any previous trading names. There's all sorts of information about dates of trading that you'll need. Then a really key bit is what's known as Appendix A. So Appendix A of the immigration rules sets out what documents you need to provide in support of your application, depending on the type of licence you're applying for and depending on your organisation. For example, some documents are mandatory for startups, which are optional for other more established businesses. Most applicants have to supply at least 4 documents. There's 4 tables within the appendix. You basically start with table 1 and you work your way through it. Sometimes there aren't any documents in tables 1 to 3 that are relevant, in which case all of your 4 documents come from table 4, or you might have 1 or 2 in the earlier tables and you make up the rest from table 4. Really important, if you're applying for a skilled worker licence, in addition to the documents, there's this information you have to supply which is quite easy to miss because it's in the kind of what looks like introductory text to Appendix A, but it says, if you don't supply this, we'll reject your application. So, and it's things like organisational charts and specific information about any individual that you're planning, that you've got in mind to sponsor. So if you've already identified someone, you're going to need to provide quite a lot of information about them and explain, even though we don't have to advertise roles anymore, you still have to explain how you identified them for the role. So if you advertised, if you used a headhunter, a recruiter, you have to give them all of that information. Basically, as much information as you can, be as transparent as possible, increases your chances of approval. I'd always say as well, include at least one more document than you need. Most applications will need the 4, but it's always a good idea to include at least 5, if you can more. So the types of documents that most employers will need to provide are employer's liability insurance certificate, PAYE and accounts office reference number, bank statements, tenancy agreement. And with all of these things, there's very particular rules about them as well. It's not, for example, it's not just as simple as providing a tenancy agreement. You have to make sure that it's signed by all parties. If it isn't, they'll reject it as a document. And then if you've only supplied 4 documents, you've then lost your, had your application rejected because one of the documents didn't comply. So it's really important to read that Appendix A very carefully. At the moment, UKVI, UK Visas and Immigration, is accepting scanned documents by email. But in the past, that's been a change since COVID. In the past, you've always had to send them hard copy original documents. So it's really important that if you're going through this process, you do gather together all of the original documents, because even though you send them scanned copies by email, they could ask to see the originals. And if you don't have them, your application will be rejected. So once you've got all your documents together, stage 2, which is fairly straightforward, is completing the online application. That's just a case of inputting everything you've gathered together about the individuals, about the business, about the documents, and inputting that all into the online form. Whoever you've identified as the authorising officer is the person that has to finish off that form. So the form can be completed by somebody else, but the authorising officer has to check it. There's a set of declarations they need to read and confirm, submit the application, obviously pay for it. The cost will depend on whether you're a small or charitable organisation, in which case the cost is £536. If not, the cost is £1,476. So a small company generally means 50 employees or fewer and an annual turnover of 10.2 million or less. So once you've submitted your application, you've paid the fee, it's then a case of sending those supporting documents within 5 working days. So this is really important to have all of your documents ready really before you submit that online application, because if you're then scrabbling around for documents and you run out of time, that's your application rejected. Do also make sure, now that you're emailing documents, check with your IT team that there aren't going to be any problems with file sizes. You can't send them a link to download documents or web share or anything like that. They're very specific. Send us scanned copies. Our own IT team said the best thing to do is to print, although it seems like such a waste of paper, but the best thing is to print documents and then scan them black and white through a scanner. That creates the smallest file size apparently. So then stage 4, you're then waiting for a decision. So you'll get an automatic email confirming you've submitted it. You might also get an email from UKVI inviting you to request priority service. Now, it's basically a lottery at this stage. If you do get invited, you complete a further short form and email it to them. They only accept the first 10 applications each working day, starting from midnight. In my experience, it's very, very difficult to secure priority service. The cost is £500, and even then they don't guarantee it. But if you do secure it, they'll aim to deal with the application within 10 working days, so 2 weeks. Otherwise, their turnaround time is 8 weeks for 80% of applications. Again, my experience at the moment is that it's taking them a long time to deal with sponsor license applications. So it's really important to build that into your timeline if you're new to applying for a license and you've got someone that you want to get and start working quickly. It's unlikely to happen quickly. The Home Office will consider your application and carry out a number of checks. They'll check all the documents, they'll conduct checks into the people you've identified as authorising officer level 1 user. Then they'll write to you to confirm whether you've been granted a licence or not. Usually, whoever you've identified as the level 1 user will receive an email with their SMS access details before you even get that letter. The SMS, the sponsor management system, is the online system within which you manage your licence and all of your sponsored workers. If granted, your licence is issued for 4 years. You have to renew it if you want to keep it after that. Your level 1 user gets that access to the system. When you first apply for the license, you can only nominate one person as a level 1 user, but once you've got the access, that level 1 user can go into the system and they can add additional people as level 1 users. Right, so once you've got your license, the next step is sponsoring an individual worker. So I'm going to focus here on sponsoring a skilled worker as that applies most widely. The requirements for sponsoring an ICT worker do differ in places. The same broad principles apply, but it's really important to refer to the ICT specific Home Office guidance if you're looking to sponsor an ICT worker, because there will be some differences to what I'm going to go through here. So step 1 is identifying the SOC code, so Standard Occupational Classification Code. So there's an online appendix for this. Again, the link will be in the pack you get, and it covers both skilled workers and ICT. You basically go to the web page, use your Control F, and then you can tap in a job title and search in that way. It's probably the easiest way because it's quite a lot of data to look through. However, do be careful because that will take you straight to a code, but that page includes table 5, which is a list of job roles which aren't eligible for sponsorship. So do be careful when you're referring to that table. Also, the header of the table doesn't flow through, so you then have to refer back to the top to see what exactly it is you're looking at. They don't make it particularly easy. Some of the roles don't qualify for ICT, but do qualify for skilled workers. So just be very careful when you're looking at those SOC codes. Step 2, once you've got your SOC code, so for example, let's say you're sponsoring a general manager, you'd tap in general manager, you'd find the code, it's a 4-digit code, it will have some alternative job titles. Just check that that's most closely matched to the job, that it's the correct, that it's eligible for sponsorship. It will say yes or no for skilled and ICT. Step 2, again, using that SOC code information, is to check the level of pay. So it explains on there how salary is calculated against hours of work. So it's important to pay attention to that as well. Now, the going rate, what's referred to as the going rate, is 25,600. You must pay them that or the minimum rate against that particular SOC code, whichever is higher. Now, the only exception to that, where the individual might be able to be paid somewhere between 70 and 90% of that salary, is if it's on a shortage occupation. If it's a shortage occupation, the person is under 26, studying a recent graduate or their training, or they have a STEM, so a science, technology, engineering, or maths PhD level qualification. If they have a relevant PhD level qualification in another subject, the salary must be at least £23,040. Just note that if you're in healthcare or education, those roles have quite different salary rules, so it's just important to refer to the relevant table in the rules. The salary can get complicated if you're looking at one of the exceptions, so do just be careful. There are still minimum levels of each salary. It's not a case that you can just ignore the minimum rates because, for example, it's a shortage occupation. They will still need to meet a minimum plus be in a shortage occupation. So really important to refer to the relevant table when you're looking at that. So step 3, once you've got your SOC code and your level of pay, is to check that that worker is eligible. So you as a sponsor are under an obligation to satisfy yourself that the person that you want to sponsor will be able to make a successful application. Now, of course, you can't guarantee that that will happen, but you at least have to go through the steps to satisfy yourself that as far as you can see, they should be eligible. So and that they'll comply with their conditions of stay, so you don't think that they're going to breach their conditions. So they have to score overall 70 points under this new points-based system. 50 of the points are mandatory that they have to score. So they have to be sponsored. They have to be sponsored by a licensed sponsor. Their job has to be at the appropriate skill level. Now, the skill level was reduced at the start of the year. It used to be level 4. It's now come down to level 3. That's for skilled worker. For ICT, it is different. So they'll get 20 points for being sponsored. They'll get 20 points for the skill level, and then 10 points for English language. Now, if they're from a country that has English as an official language, then they'll automatically get that. So USA, Canada, Australia, for example. If they hold a degree that was studied in English, they'll also automatically get it. So they might be, for example, from China, but they studied in the UK and have a degree from a UK university. That will be fine too, it will be assumed. In all other cases, they'll have to take an English language test. That has to be with an approved provider. Again, there's a website where they can look all of that up, and then they have to provide proof of having passed that English language test when they apply for their visa. The cost of the tests are around £50, depending on the provider. Another point, actually, just to note about salary, is that you must make sure that the salary that you're quoting is their guaranteed salary and doesn't include any allowances. So it has to be their basic salary. You can't include commission, you can't include bonuses, even guaranteed allowances, the rules say can't be included. So it's just really, that salary piece is really important. Right, I'm going to move on to, once you've gone through those initial steps of identifying, okay, yeah, we think this person will be eligible and we can sponsor them. Your next step is to assign them a certificate of sponsorship, a COS. Now, there's no requirement to advertise anymore, which is great because the RLMT was a pain. That's except for religious workers, but I'm assuming that won't apply to anyone here. So once we've satisfied ourselves around those rules on the previous slide, you can go ahead and assign a COS. So the COS is a digital record, but you can print off a copy, you can give a copy to the individual. It's a confirmation from you as a licensed sponsor that you want to sponsor that person. You're satisfied they can meet the relevant immigration requirements, you're eligible to sponsor them on that relevant route, and you agree to abide by the terms and conditions as stated on the sponsor management system, so the immigration rules basically. The COS has to be assigned by the level 1 user, or a level 1 user, and note that level 1 users can't assign COS to close family members. So if you're in a situation where it happens to be a family member that is being sponsored, you would need to source a different level 1 user to assign that certificate. So we used to have restricted and unrestricted certificates. Some of you might be familiar with that, but there used to be a limit on the number of restricted certificates. So that was when someone was not already in the UK, only a certain number a month could be sponsored. So that's gone, but there are still 2 types of certificate. So we don't have the limits, but there are still the 2 types. So you can lose your license if you assign the wrong type of COS. So it's really important to understand the difference. Luckily, it's quite easy, as long as you don't get the names mixed up. Oh, excuse me, I've gone too far. So an undefined certificate is for someone who's already in the UK. So they might be here on a different type of visa permission. So perhaps they're already working for you on a YMS visa and you're looking to switch them to skilled worker because they're at the end of the 2 years. Or they might be working for another sponsor. Whatever the situation, it's known as switching, whether they're switching employer or they're switching immigration category. When you first apply for your license, one of the things you have to do is specify how many certificates you're requesting for the first year. That's how many undefined certificates, sorry. You have to justify the number that you're asking for as well. So you can't just pick a number out of thin air and go, let's have 10. They won't give it to you. You have to explain why. So you might say, well, we've already identified one person, plus we've got someone that we already sponsor, or someone that's already on a YMS that's switching to a skilled worker, so we therefore need 2. That sort of thing. The allocation only lasts for a year, up to April. Come April, if you haven't used the certificates assigned that are granted to your licence, they'll just fall away. And you'll start the new April year with 0. So every April, you need to apply for a new allocation if you're going to need them. You can still apply for an allocation during the year, but it does take time. And I've found it at the moment, it's taking anywhere up to 8 to 12 weeks to get more certificates. So it's really important that you make sure that you plan ahead and that you've got certificates sitting against your license that you think you might need to use for that year. So this other type of certificate is the defined certificate for someone who's applying for a visa from outside of the UK, which is known as entry clearance. So if they're not already in the UK, you must use a defined COS. So you can't use a COS that's sitting in your license already. You have to apply for a defined COS on a case-by-case basis. So you apply for them from within your SMS, and you have to provide the same sort of information. You have to explain why you've identified that person, how, again, even though you don't need to advertise, you still have to explain, what sort of recruitment process you went through and why it is you couldn't identify a resident worker. So you apply for the defined COS. They do tend to come through within a day or so. So it is quick to get those. Once you've identified the correct COS that you need to use, whether it's undefined or defined, and then it's been granted to you, you then have to assign that certificate to the individual. So there's certain information you have to include on the COS for it to be valid. It includes the route that you're sponsoring them on, their personal details, their work address, information about their job. One of the important things to include is their SOC code. So that first piece you did on identifying the SOC code, identifying the correct salary, you have to make sure that all of that goes in there and is consistent. Another thing to make sure of at the same time is that the contract of employment that's been issued to them or offered to them is consistent with what you're putting in here, because they will probably, it's usually a good idea for them to take that with them to their visa application appointment. And if it doesn't match up, the salary doesn't match up, it will be refused. And often the Home Office will ask for the contract if it hasn't been provided. If you sourced the individual through an agent, you have to provide the details of who that was. So if it was a headhunter or an agency, you have to give that information. There's a question in there about whether the sponsor will certify maintenance. Now, I usually suggest to employers, to sponsors, that you just tick yes. Otherwise, the individual has to provide certain information and have certain minimum amounts in their bank account for a certain period of time. It's much easier for a sponsor to just tick the box that says certify maintenance. In reality, it doesn't really impact any employers. It just means, you know, this person won't suddenly have nowhere to live, and you, the sponsor, will make sure that they're looked after, you'll pay them, etc. For some roles, you have to say whether they're subject to the ATAS, which is the Academy Technology Approval Scheme, and then there might be additional information depending on the route that you're sponsoring them for. You have to pay the fee for the COS unless there's an exception. So individuals from certain countries are exempt from the fee. It's not Europe. Although there are some European countries in the list, it's not all European countries. But the calculator that you all received a copy of has got the information in there, but it includes countries like Portugal, Germany, France. The fee is £199, or for a temporary worker, it's £21. You will usually also have to pay the immigration skills charge. So this is a cost that you're not allowed to pass on to the individual worker. It applies whether it's a skilled worker or an intra-company transfer. There are some exceptions if the person's already been in the country sponsored before this fee applied, they might be exempt. There's also exemptions for graduate trainees, someone who's here less than 6 months, for example. The amount that you'll pay will depend on the size of your organisation and how long you're sponsoring them for. So when you assign a certificate, you have to, one of the other bits of information you have to give is how long you're assigning it for. Now, the skilled worker visa, can be assigned for up to 5 years to start with, but there's now no limit on how much you can extend it for. But generally, employers will assign a certificate for perhaps 2 or 3 years. You don't know what might happen. The person might end up leaving, moving on, it doesn't work out, and you don't necessarily want to pay all that up front. Also, if they're switching from another employer, they might have already been here for 3 years on a skilled worker visa, in which case, if you sponsor them for just 2 years, after 5 years, they can probably apply for indefinite leave to remain. So you have to think about how long you want to assign that certificate for. But how long you are assigning it for will then determine how much you're paying for the immigration skills charge. It will also determine how much the individual pays for their visa. So a small or charitable organisation will pay £364 per year of the certificate. Otherwise, it's £1,000. So for a large company, if you're assigning a 3-year COS, the immigration skills charge will be £3,000, plus the £199 if applicable. So once you've paid for that, you've assigned it to the individual, you then pass that COS reference number to them. You can download a copy and just give them the COS. That's usually easiest. They'll then use that to apply for their visa. They do that online, whether they're in the country or out of the country. They input all of the information. They book an appointment at a visa centre and wait for their decision. They might need to do the English language test. In most cases, they'll also have to pay the NHS surcharge. The immigration health surcharge, so similar to the skills charge, has to be paid upfront for the full length of the visa. For most visa, there are some lower fees in certain situations, but for most people it will be £624 per year. So £3,120 for a 5-year visa. That skilled worker calculator, cost calculator that we've supplied to you works out all of these total costs. So the costs for you, the sponsor, and the costs for the individual. I've tried to factor in every scenario, so it should give you a fairly accurate estimate of the cost involved. It applies the various discounts that apply in certain scenarios. So that should give you a good idea. So just to give you an example, this is taken from that cost calculator, and I've put an assumption here that we're applying for a 2-year COS and visa. The COS fee is payable. I've said that the English language test is required. There's no discount applicable. No, it's not a shortage occupation. We're a small sponsor, and the applicant is already in the UK. So based on that, I just wanted to see, I'm just going to launch another little poll and just see if what you think the rough cost of sponsorship is given that scenario. So we're talking about the cost for the employer plus the cost for the individual. Roughly, what do you think that total cost will be? Okay. It's interesting seeing them coming in and it all ticking up. Okay. I'll show you what everyone voted. So the most popular choice was 3,000. So let's have a look. It works out as just over 2,000. So this screenshot doesn't include the notes, but each of those rows has notes at the end. If you've had a look at the calculator, you'll know it gives further explanation, for example, of who qualifies for the nationality discount. If you wanted to apply for priority service, it would be on top of that. So I talked about priority service earlier to do with the sponsor license application. That is very much a lottery. The priority service for applying for a visa is different. It's not a lottery. If the service is available at the visa centre that the individual is applying to, then they pay for it, they get it. It's £500 for a 5 working day standard priority. It's £800 for super priority, which is next business day. The costs can steadily rack up. If you don't already have a sponsor license, that cost is on top of all of this. So for example, in this particular example, a small sponsor would be looking at a total of around £3,000, including the sponsor license application without any priority. So you were all pretty spot on. Really important points that I just wanted to sum up from all of that. Timings is really the key one. I know for most employers that I speak to, it's we've got someone and basically want them to start, next week, next month. It's usually quite tricky to achieve that, particularly if you don't already have a sponsor license. If the person's already working for you, it's usually not an issue. As long as you put the application they submit their visa application before their current permission runs out, they can continue working for you. So for example, say you've got someone on a YMS visa and that YMS visa is going to expire on the 31st of August. You would need to assign a certificate of sponsorship to them, and they would need to submit their visa application online before the 31st of August. If they do that, it's fine. They can continue working for you until their visa application is decided. However, if you don't already have a sponsor license and you need to apply for the license first, it's very unlikely that you'll get that done in time. You'll have 2 months. It would be challenging in the current climate of how long the Home Office is taking to process things. So it's so important to factor in all the relevant timings. You can lose your licence if you fail to operate within the rules, manage your sponsored workers properly and your licence correctly. Losing the licence would mean having to immediately dismiss everyone that you sponsor. Those individuals would then have 60 days to find a new sponsor or leave the country. So it's potentially, really significant impact. So timing's important from your practical point of view, but then from the point of view of complying with your obligations, you must make sure that the employment is genuine. You can't make up a role for someone. Must assign the correct cause. One that people don't really think about, but you can't share SMS login details. If your level 1 user leaves and before they left you didn't get them to give access to someone else, you can't just use their access details to go in and manage it yourself. If the Home Office found out, if UKVI found out, at worst you could lose the licence. And there is a manual process. If you find yourself in a situation where your AO or your level 1 user are out of the business, there is a manual process by which you can contact the UKVI and get a current employee access. Really important to report changes and report them on time. So the guidance contains a list of changes relating to the individual and relating to the organisation that must be reported usually within 10 working days. One really important thing to note is that where someone's role is changing, before it happens, you must check whether that role change would involve a different SOC code. If it moves them to a different SOC code, you have to assign them a new COS and they have to apply for a new visa. Really important, therefore, going back to what I said at the beginning about having those systems in place to escalate changes internally. And lastly, make sure that there's a consistency with their visa permission once they've got it. So, stay on the same role, vaguely the same salary. Usual salary increases are fine and you don't have to report those. But otherwise, make sure that they're operating within the confines of that COS. Interesting note, they can actually work for third-party companies. As far as their immigration status is concerned, you contractually might not want them to do that, but they are allowed to. They don't have to be sponsored by that other employer, but it would have to be the same, basically the same job. It has to be the same SOC code. It can't be any more than 20 hours per week, and it has to be outside of the normal working hours that they would work for you. Seems unlikely that that would happen in practice, but it could potentially, depending on the situation. So interesting point for sponsors to note. So that's all the sponsorship side of things. I just wanted to talk a little bit about business visitors. This is another question that's coming up quite a lot now, especially with our new rules for European nationals as to, well, can we just have someone visit as a business visitor and not have to go through all this sponsorship malarkey? It depends what they're going to come to do. So we don't have any such thing now as a business visitor visa. There is just a standard visitor visa. For up to 6 months, someone can come to the UK as a visitor without any sponsorship. Now, there are rules within that as to what business activities the person can do, and they are quite limited. They can go to meetings, they can go to conferences, they might be able to give some talks, speeches. They can't be paid by the UK. They can't do anything that constitutes work. They specifically can't do a work placement or internship. They can't sell. They can't provide goods and services. So it's really important that if you are having a business visitor come from a company abroad, you're very clear on what they can and can't do while they're here. You don't have to apply for a standard visitor visa before coming to the UK, but if you've got someone coming as a business visitor, you might want to, because if they turn up to the border and are asked, what are you doing here? And they say, oh, I'm coming for meetings for my employer, they're probably going to get quite a lot of scrutiny. So it might be better to apply for the visitor visa in advance and have that clearance before they come. Moving on then to right to work checks, finally. So really important point here is to check the right to work of all employees. Avoid, seems obvious, but plenty of employers don't ask for evidence for everyone, but avoid asking for evidence only from obvious foreign employees. It carries a real risk of discrimination complaints, and it won't satisfy the Home Office. You can't, though, conduct retrospective checks on existing employees who provided valid evidence at the time they started. So this is one that's created, understandably, a lot of confusion, especially with EU nationals and employers thinking, right, well, we now need to check the status of all of our EU employees. You don't. When they joined you, they provided you with valid evidence, which was their EU passport. If you look at the Home Office right to work checklist, an EU passport is in list A, which means that provides an excuse for the duration of their employment, and you never have to do another check. The rules are not retrospective, so the fact that they now require settlement status going forward doesn't mean that you have to go back and ask for evidence of that. And in fact, you can't. So you can't insist on that. So if you try to, again, it could lead to claims of discrimination. But, big but, if you have good reason to suspect that an employee hasn't applied for EU settled status, or has and it was rejected, and you're concerned that they're working illegally, then you do need to think about whether you should make a report to the Home Office. Now, there is a criminal offence of knowingly employing an illegal worker, and it carries penalties of an unlimited fine and or a prison sentence for the individual's managers who knew of up to 5 years. So now that sounds all quite scary, I mean it is, but do exercise caution. This doesn't mean, oh, I'm not sure if so-and-so has applied, so I better make a report to the Home Office. It doesn't mean that. It's where you know, or you have really good reason to suspect. They might have come to you and said, oh, my settled status application has been refused. That's knowing, or having good reason to know. If you think it can be a tricky situation, so if you think that you might be in that situation, take advice. You don't want to, on one hand, be trying to comply with immigration laws and not land yourself in civil and criminal penalties, but on the other hand, you don't want to be facing an employment tribunal claim. So take advice and weigh up all of the risks. For employees starting a new role, it's been extended now, so from September, because at the moment we can do the electronic checks, but once that reverts back to manual checks, unless they give you a share code, so there's likely to be people who've got EU settled status give you a code and you go online and you tap it in and you get confirmation. Otherwise, a manual check is original documents, you check them in their presence, check they're genuine, etc., make the copy and put the correct notes on the copy. I would always use the Home Office right to work checklist. I get quite a few queries from employers saying, oh, is this acceptable? With an example of the BRP card attached. If you just follow the right to work checklist, it's really quite good, and it will tell you exactly what you can accept and which list it falls into. So something which falls into list A means you don't have to ever check their right to work again. Something that falls into one of the other lists, you have to conduct follow-up checks at the appropriate time. That checklist also tells you how to check that the documents are genuine. You're not supposed to be an expert, but you're supposed to do enough to comply with the checklist. And it tells you how to copy the document and what to write on it. If you've done those checks correctly in line with the checklist, and then the Home Office came to do an audit and found that actually Joe Bloggs is an illegal worker, they gave you a fake passport, if you had done the check according to the lists, you filled it all out, you've taken the copies correctly, you checked it in their presence, etc., most likely you wouldn't suffer any penalty at all. If you hadn't done the checks, you're looking at civil penalties of fines of up to £20,000. If you've got a sponsor license, you may lose it. If you knowingly accepted a fake passport or knew that they were an illegal worker, obviously we're going back to those quite scary criminal penalties. So that right to work checklist is a really useful tool, not only just to help you guide you through those checks, but in the event of an audit, you can show the Home Office, here's my list, ticked everything, there's the check I did. I worked with a client a few years ago who they do all of their checks in that way, and they actually received a call from the Home Office one day saying, you have XYZ employee who we believe provided you with a fake passport. And they actually roped them into a kind of sting operation, which was quite interesting / exciting. But ultimately, they didn't suffer any penalties at all. The Home Office were very happy that they had done their best to conduct the checks. They're not experts. They weren't to know that the passport was fake. They'd filled out their checklist. So yeah, I can't emphasise the importance of that enough. And hopefully I haven't spoken too quickly, but I've just about managed to finish before 11. So I've got a few questions I'm just going to go through. So Samantha, I think I've just covered that point about the EU staff. So yes, you shouldn't be undertaking retrospective checks, absolutely not. Also, if you've got EU employees who have submitted their settled status application, but they're still waiting for an outcome, there are tens of thousands. The Home Office is completely overloaded. You don't have to worry, you can continue to employ them. The Home Office has made very clear that anyone whose application is in progress retains all of their rights and can continue to work. So you don't need to worry. They just need to show you, basically show you evidence that that is in progress. So I can provide you with the exact wording about what it is they need to give you. Samantha's you've also asked, there are limited opportunities to employ non-skilled staff. You're in education. Okay, yes, yeah, exactly. So the minimum skill level is 3, which has lowered quite a lot. But I don't know, what your specific roles are and whether it would be low enough for your needs. If not, unfortunately, you can't drop any lower than that. I would have thought teachers should fall within the acceptable SOC codes. And as I say, there are different salary rules for education. So under the new rules, you might be okay for many of your roles, but I'm happy to pick that up and speak to you about that separately. Someone else has asked, a couple of people have provided you with their share codes. What do you do with those? So you go online, and there's a website to check. If you Google check EU settled status.gov, it will bring you to the government page. I can't remember now if I've actually put the link on the handout, but I can supply it. But you basically put the code in. I think you might have to provide their name as well, but you put the code in, you click a couple of buttons, and it presents you with a sheet that has their photo and confirms, yes, this person has the right to work. And then you keep a copy of that on your file, as that's your right to work evidence for them. If you shouldn't check their current status, should you actively ask employees to send proof of application or status, or just wait for them to come to you? So if you're talking about a current employee, you don't do anything. If they're a current employee, at the time they started, they had the right to work. So say they are a German national, they started with you in January. When they started, they provided a copy of their German passport. if you follow the right to work checklist, that's in list A, it's an EU passport, they have a unlimited right to work. You have an unlimited excuse against the civil penalty for employing an illegal worker. Tick, you don't have to do a follow-up check, done. There is absolutely no requirement, and you can't insist on going and getting additional evidence for them. So you've done your checks. If the Home Office came in tomorrow and said, let's see your right to work checks, and said, well, this German person hasn't applied for EU settled status, you'd say, yeah, but they started in January and here's the check we did and it was valid. That would be fine. It's only if you know. So if that person came to you and said, I haven't applied for settled status and it's now the 1st of July, or I did and it was rejected, that's where then, you know, we start to run into issues. But otherwise, they gave you valid evidence at the time, that's it. If they voluntarily supply you with share codes, fine, but otherwise, no need to go back. Yes, so you've just asked that. If they've shared it with you anyway, what do you do with it? You can carry it out. You can look it up and keep it on their file. There's no harm in doing that. What I'd probably do is put a note saying they voluntarily supplied this, although we already have valid evidence for them on file, something like that. But just obviously, I'm not talking about any GDPR stuff, so just bear in mind any GDPR rules around that. If they've provided you with an EU passport, do you have to request an up-to-date one when it expires? No. So the right to work checklist is very clear that at the time you carry out the check, the passport is valid. If it is, tick, your check's done, you don't need to do a follow-up check, that's it. If someone provided you with a British passport, you don't have to go and check it again when it expires. Exactly the same applies. If it was valid at the time it was provided to you and it fell into list A, that's it, and there's no follow-up checks required. It's only where your evidence, the evidence that they gave you, falls into one of the other lists, that it's a time-limited right to work, and then that's when you need to do the follow-up check. Okay, so hopefully, I think I've answered now. Answered that one. Yeah, okay. I think I've answered all of those questions on there. So, wow, and it's only 3 minutes past 11. So I hope I haven't talked too quickly. I tried to get all of the information that I wanted to cover out there and answer your questions. So, yeah, if I will, as I said, we will send you a copy of the recording. We'll send you a really detailed handout that covers all of that information I spoke about. If there's anything else in particular that you've got a burning question about that relates to something I spoke about, happy to answer that. My contact details will be on the handout we send you. But otherwise, yeah, if you need support with visa applications, sponsor license applications, I do all of those. I'm one of the senior employment lawyers, as well as handling business immigration matters for clients. So any of that I can help with, just get in touch. So I hope you found it helpful. Thanks so much, everyone. And that's it from me. So hopefully speak to you soon. Thanks a lot, everyone. Bye.